Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. The chief flaw in the Constitution is letting the 9 justices of the Supreme Court decide how much work they want to do. That's what my former boss and former Chief Justice of the Missouri Supreme Court told me. And I think he's right, at least in part. Here's what the Constitution says about the Supreme Court's jurisdiction. It's from Article 3, Section 2, Clause 2. In all cases affecting ambassadors, other public ministers, and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction both as to law and fact, with such exceptions and under such regulations as the Congress shall make. So the jurisdiction is fixed by the Constitution. However, there are some tweaks to the jurisdiction that occur through Congress. So when Missouri sues Texas, the Supreme Court is a trial court. When Texas sues AT&T, it's an appellate court. But here, Congress has provided the Supreme Court with an out because it has established intermediate courts of appeal. Those are called the circuit courts of appeal, and there are 13 of them. So a case reaches the Supreme Court when it's something other than a state suing a state only by something called a writ of certiorari. And a writ issues only when an opinion has been written by one of the circuit courts of appeal. Now, one way to think about this is that the circuit courts of appeal are error-correcting courts. In other words, if the district court makes an error, let's say it admits evidence that it clearly shouldn't have admitted, well, the circuit court corrects that error, writes an opinion explaining what the court did and why it screwed up, and then it remands the case back to the district court. And their take on that piece of evidence becomes precedential within that circuit. Now, it doesn't bind the courts in any other circuit, but it does bind the courts in that circuit. So, for example, when the Seventh Circuit makes a decision, Illinois, which sits in the Seventh Circuit, all of the district courts in Illinois, all of the federal district courts are bound by that analysis and that opinion. But what if the Circuit Court of Appeals gets it wrong? Well, federal courts of appeal routinely handle more than 50,000 cases each year. 10% or fewer of those decisions are appealed by writ of certiorari to the Supreme Court, which in turn hears oral arguments in fewer than 100 cases every year. Thus, the vast majority of Court of Appeals decisions are final and are binding on lower courts within that circuit. So in other words, roughly 2% of the cases that are appealed by writ are taken and decided by the court. And just because the court takes a case doesn't mean it will be decided. The court can, for example, remand a case that it has taken if a case that they have recently decided gives the lower court instruction on how to handle that case. For example, when it issued the Bruin decision, which was a Second Amendment case, there were other Second Amendment decisions that were coming up on appeal. And as a result of that, the court remanded those with instructions to consider that appeal in light of Bruin. And of course, the more liberal circuits did not actually reconsider. They just sent the case back down, and it wound up eventually going back up to the Supreme Court and will probably be decided in this next term. But in many cases, never make it to the Supreme Court. And that's not because the Supreme Court doesn't want to hear them. It's because the Supreme Court never knows about them. And one of the places where this happens a lot, and a lot more than it should, is in the bankruptcy contest. Now, in one case that I was involved in, as a creditor of a company taking bankruptcy, we objected to the payment of fees to a law firm that was, in our opinion, conflicted. Now, there is a statute that requires that a bankruptcy court review a disclosure statement filed by any professional that the bankruptcy trustee wants to hire. And if they are satisfied that the disclosure meets all of the requirements of the statute, then they can approve to hire that individual. Well, 2 days after filing the petition for bankruptcy on October 14, 2020, the debtors in that case sought authority to hire certain professionals. These are called ordinary course professionals. In other words, if they had a relationship with a law firm prior to the bankruptcy, they basically just want to continue that relationship. Well, a bunch of creditors objected, including us, and also the U.S. Trustee's Office did. Now, the U.S. Trustee is different from the bankruptcy trustee because the bankruptcy trustee in a Chapter 11 case is almost always the debtor itself. But in this case, the United States Trustee is there as a referee, sort of trying to keep the system honest on behalf of the government. So the U.S. Trustee objected because the motion did not provide sufficient information to support a conclusion that the services to be performed by the professionals, including those added after the deadline to object, were completely unrelated to the bankruptcy case. And that's the standard in the statute. In spite of that, the court approved the requests to retain those professionals. Then, nearly 6 months after that initial approval, another law firm sought approval back to the date of the petition. And it did this in February of 2021 after the petition had been filed in October of 2020. And essentially they asked for the court to say, hey, we've been working this whole time. We just didn't get around to filing a petition. The sun was in our eyes. We didn't know the gun was loaded. Then, just do what you're supposed to do here, Judge, and give us permission to represent this poor debtor. Well, they're not supposed to do that. But the court did it through what's called an order nunc pro tunc. Now, nunc pro tunc is Latin for now for then. Why they don't just call it a now for then order, which would probably make it much simpler and would also probably remind courts that they can't use it in the way that this particular court did, I don't know. I know that lawyers love to use Latin and will go to Google Translate to find a way to make a phrase sound Latin. And the reason I know that is because I've seen it done in cases. A parade of horribles became, I forget exactly what the term was, but I had to go to Google Translate to find out what that meant, and it came out as a parade of horribles, which I thought was pretty funny that a more recent phrase, a parade of horribles, would somehow be used in Latin. Because usually that's for things that are sort of ancient and historic. But anyway, I digress. So a nunc pro tunc order is allowed to be issued. Federal courts are allowed to issue them, these now for thens, to reflect the reality of what has already occurred. In other words, if the court took an action on January 1 and then didn't record it, and then somebody came back in February 1 and say, hey, remember when you said on the record in January that you were going to do this? Well, you didn't do it, and now we want you to sign this order nunc pro tunc to record what you did previously. That's how they are supposed to be used. Such a decree presupposes a decree allowed or ordered but not entered through the inadvertence of the court. Now, one court, when they were discussing these, put this kind of colorfully. It said, nunc pro tunc orders are not some Orwellian vehicle for revisionist history, creating facts that never occurred in fact. Put plainly, the court cannot make the record what it is not. So the court's approval, retroactive to the petition date, was unlawful. And what was interesting was the Supreme Court had decided a recent case, the Roman Catholic Archdiocese of San Juan, Puerto Rico versus Acevedo Feliciano, which is 140 Supreme Court 696. It decided that in 2020. And it stated emphatically that a nunc pro tunc order could only correct the record to what actually happened. It could not backdate what did not happen. But in spite of this, and in spite of us arguing this in briefs And in motions, the court did what it wanted to do and approved the appointment. Well, the creditors appealed, and we pointed out the error, and the appeal went to the district court, not to the Circuit Court of Appeals, because bankruptcy appeals come to an appeal from an Article I court. They are not an Article III court, so they're handled differently. If it had been an Article III court, it would have gone up to the Court of Appeals. But in this case, it goes to the district court. And the district court drug its feet. It took forever to get to this case. And when it did, we didn't even get to orally argue the case. They decided it on the briefing, and they just affirmed the bankruptcy court. And of course, by that point, the bankruptcy had been confirmed, and the Third Circuit takes the approach that you cannot unscramble that egg after it's been scrambled. So as a result, that case will never get to the Supreme Court, even though it probably should. Actually, it wouldn't have gotten to the Supreme Court if it had gone to the Third Circuit, because I'm pretty sure the Third Circuit would have been obligated to follow the SCOTUS opinion in Acevedo. But it never got that, so it couldn't correct the error at that level. So back to the issue of what kind of court the Supreme Court is. If the circuit courts are error-correcting courts, what are the Supreme Court? The Supreme Court is not really there to correct errors. I mean, it does correct them, sure, but that's not its primary function. Its primary function is to keep the law consistent throughout the land. In other words, one rule for one particular thing, and that rule to be applied universally. Unfortunately, because there are so many ways that things can be characterized, the idea that you have one rule that fits, sort of one-size-fits-all rules doesn't really work in a litigation context, because lawyers are pretty good about making their case seem a lot different than the case that came before. So, circuit courts of appeal will reach different decisions on similar issues, and there'll be a different rule in the Eighth Circuit than there is in the Second Circuit, or a different rule in the Seventh Circuit than there is in the Ninth Circuit. A case normally gets accepted in only two scenarios. The first is where it's an issue of general interest and importance. For example, Colorado versus Trump is a good example there. And the second is where the courts of appeals are in conflict with one another. Now, I want to give a shout out here to people who are really interested in the Supreme Court. There is a place online called SCOTUSblog.com. Now, the SCOTUSblog.com is a great place to go to get authoritative information. You can get a sort of a feel sometimes for how the court is going to decide things. And of course, that's just the opinion of the people who write for that blog, but I'd give them about a 95% accuracy rate. Now, cases get to the SCOTUS by a petition for the writ of certiorari, or what's called a cert petition. Here is a recent cert petition. Now, every now and then, a lawyer files a really good cert petition, and I think this is a pretty good one. I'll explain a little bit more about that in just a moment, but first let's look at what the body of this petition says. Now, usually the question presented is a one or two sentence statement of the key question in the case. Here, I think this is really important what the lawyers did. They provided enough history that the Supreme Court can make a decision. In 2018, the Federal Trade Commission obtained a punitive disgorgement award against the petitioners, which was a small credit repair company. I'll have more on that in a second. And its owner. The judgment ordered petitioners to surrender the company's total gross revenue without any reduction for legitimate business expenses pursuant to the Trade Commission Act. This court ultimately granted review of that very decision to address the use of Section 13B in FTC versus Credit Bureau Center, LLC, 141-194, July 9, 2020. That case was consolidated with AMG Capital Management, LLC, and this court unanimously held that Section 13B does not authorize the Commission to seek and a court to award equitable monetary relief such as restitution or disgorgement. On remand, however, the FTC asked the district court to reimpose the prior judgment pursuant to Section 19 of the Federal Trade Commission Act. So Okay, now when we're changing horses, Judge, we don't want to rely on 13 anymore. We want to go to Section 19. And in its opinion, granting the request, the district court allowed the FTC to seek the same remedy for the same reasons for the same victims via Section 19 as it did under Section 13B. Now before this court for the second time, petitioners present the following question: whether Section 19 of the FTC Act, which prohibits the award of any exemplary or punitive damages, empowers the Commission to seek and a court to award disgorgement of a business's gross receipts as punishments for violating the Act, and therefore impose the same remedy for the same reasons for the same victims under Section 19 as was done under Section 13B. Well, that's a really great way to get the court on your side, saying essentially, hey, you already decided this case once, and now we're back again because the FTC changed horses in the middle of the stream. So the petition starts this way. It shows the parties to the proceeding and the corporate disclosure, and then it has a statement of related proceedings. So these are all of the cases that are related to this particular appeal here. And as you can see, there's 6 cases that are prior and that have been decided starting in 2018, and we're now in 2023. Of course, now it's 2024, so that's even worse. That's 6 years of litigation to get to this point. Well, then it goes to a table of contents, and here we find out the 3 main reasons why they sought certiorari. The panel decision conflicts with this court's equity jurisprudence. The Seventh Circuit has created an important split with the Ninth and 11th Circuits, and it's an end run around AMG Capital, which is the first of these cases, and it presents an issue of paramount importance. So this is how you get something in front of the Supreme Court. You do it by filing one of these writs and making it very compelling. Now we'll have to see whether or not that happens, although I have to tell you, this company is probably not a very sympathetic victim. Credit repair companies are almost never what they claim to be. The idea of credit repair is in fact a scam. And that's because once you damage your credit, it's going to take a long time to actually repair it. And in fact, the only thing that really does repair your credit rating is time. And of course, paying your bills. But what these credit repair companies can do is they can work a little bit of magic for a very limited time in order to help you get something that you might want. While the defendant is not particularly sympathetic, the issues raised are fairly important, and there is split in the circuits, so we'll have to see whether or not SCOTUS will actually take the case. And this is a federal case where the Seventh Circuit has affirmed the district court, and it's done so by splitting with the Ninth and 11th, and the court might very well have an interest in taking that case. So that's what I have for you today. I hope that explains for those of you who have been asking how a case reaches the Supreme Court. If you have questions, you know what to do. Put them in comments or send me an email, and the email address is right up there. So yesterday I did a kindness for my son-in-law. He is an electrical engineer, and he's under contract for a nuclear power plant, and he does math for a living, and he works from home. He spends sometimes 15 hours a day grinding out different equations that keep a nuke plant from becoming a mushroom cloud. And yes, I know they don't actually turn into a mushroom cloud. That was hyperbole, but I go for jokes whenever I can. He spends that time focused very intently on his work because, an error in his work could be pretty bad. And because he is very conscientious, he spends a lot of time working on that. And he has a little office down in the basement of his house, sort of deprived of sunlight, and kind of works like a mole all day long. And that's no fun. So yesterday, I brought him a Coke from the local Quick Trip. And I put it on his front porch, and I sent him a text and said, hey, when you take a break, there's Coke on the front porch. Have a great day. And later on, he told me that it really made his day. So the people who are our family are the folks we should first endeavor to receive our kindnesses. So if you have the opportunity today to do a kindness for your family members or someone else, please take advantage of it. God blesses us when we're kind to other people. And after you do that, come on back down here tomorrow and we'll chat about something else that'll hopefully be as interesting as this one was.